Your city can legally tear down your house. It doesn't have to send you a bill first, a fine first, or even a warning that costs you $1. In cities across the country, the very first letter you get about your home can be the order to demolish it. Not a citation, not a fine, the order itself. And this isn't some obscure edge case buried in a zoning manual nobody reads. It's an active, ordinary part of how American cities operate. That's not a loophole. It's the system working exactly as written. And it happened to a man who lived on Lawton Street in southwest Atlanta. A man who owned his house outright, free and clear. Everett Tripodis' city sent the notices that are supposed to go out before a house can be condemned. Except they went to the wrong address. Investigators later found the certified letters had been mailed to Lawton Avenue, zip code 30314. Tripodis' actual house sat on Lawton Street, zip code 30310, about a mile and a half away. Close enough that the zip codes look almost identical on a page, far enough that a piece of mail never had a chance of finding it. The letters came back stamped "Return to Sender." The city demolished the house anyway. Then the city sued him for more than $68,000 in demolition costs, trying to force the sale of the empty lot where his home used to stand. The city that lost his mail was now asking him to cover the wreckage. So how is any of this actually legal? It sounds like the kind of thing a city would need a court order for, a judge, a hearing, someone weighing both sides before a house comes down. It usually doesn't work that way, and the reason takes only one idea to understand. Here's the one distinction the entire system rests on. Government taking your property is legally different from government destroying a dangerous property. If a city takes your land to build a park or a highway, the Fifth Amendment requires it to pay you fair market value. That's a taking, and the public has to fund it. But if officials decide your house itself is the hazard, the law treats it differently. Your home stops counting as an asset and starts counting as a threat. The same category a state uses to shut down a factory that's poisoning a water supply, or to destroy diseased crops before they spread. And once that happens, the government typically doesn't owe you anything for it. That's a rule the Supreme Court set in 1887 in Mugler versus Kansas, a case about a state banning a use of property that was genuinely dangerous, not seizing land for a public project. And it still holds today. And this isn't just Atlanta. Detroit alone has demolished roughly 27,000 houses since 2014, a scale that makes clear this isn't a one-city quirk in an outdated ordinance somewhere. It's a tool cities across the country reach for regularly. But the misaddressed letter wasn't even the worst-case scenario.
What happens when a city doesn't have to send a letter at all? In Los Angeles, the municipal code lets building officials skip notice entirely. No notice, no order, no hearing, the moment they consider a structure an imminent, extreme, and immediate hazard. Cleveland's code allows nearly the same move whenever an official believes there's immediate danger to human life. Researchers reviewing ordinances around the country found that most jurisdictions keep some version of this emergency lane running alongside the normal process.
The logic makes a kind of sense. A collapsing wall doesn't wait for a 30-day comment period. But in either city, the only hearing an owner typically gets happens after the demolition crew has already come and gone. And by then, a hearing can confirm what happened without being able to change it. You'd assume a court would strike that down. One homeowner tried. In 1994, the Sixth Circuit Court of Appeals ruled on Harris versus City of Akron, where the city demolished a man's 2-story brick building with zero advance notice, relying entirely on its emergency provision. Harris didn't just complain, he brought in an expert witness who examined the building and disputed that it was ever a real emergency in the first place. Brick walls, the expert argued, don't become an imminent hazard overnight. None of that mattered to the court. The judge's answer was blunt. You can argue the city got the facts wrong about your building. That doesn't mean the city denied you due process. the constitutional guarantee that you get fair notice and a genuine chance to be heard before the government takes something from you. As long as some way to seek damages existed afterward, the court said the process itself held up. Practically speaking, once an official calls your house an emergency, that label is extremely hard to undo in federal court. So why did one homeowner lose everything while another homeowner beat the city in court? It came down to one thing: whether the hearing the city promised was real. Take Lisa Haddon in Cleveland. June 27th, the city gives her 30 days to fix fire damage on her home, or appeal. June 29th, just 2 days later, the city declares an emergency. July 15th, the house is gone, 16 days before her own 30-day window was even supposed to close. August 5th, the certified letter confirming all of it finally arrives. A notice about a house that no longer existed. Haddon said the home held roughly $70,000 of her belongings: furniture, records, everything a household accumulates over years. A federal judge refused to dismiss her case, ruling that whether a real emergency ever existed was a question for a jury, not something a city could simply declare true by fiat. Then there's Michael and Rebecca McIntosh in Madisonville, Kentucky. After a tenant complained about mold, the city condemned their mobile home. Mr. McIntosh did exactly what the ordinance told him to do. He wrote letters, he made phone calls, and he asked repeatedly for the hearing the city's own code promised him in front of something called the Local Appeals Board. He wasn't fighting the system from outside it. He was following its own instructions to the letter. The city refused and demolished the home anyway. When the case reached the Sixth Circuit Court of Appeals in 2025, the city's own zoning inspector admitted something remarkable under oath. The Local Appeals Board didn't exist. It never had. An impressively thorough way of not having a board. Not underfunded, not backlogged, not slow to convene. Simply never assembled in the first place, while the ordinance kept promising it to homeowners who asked. The court ruled that a notice promising a hearing that can never happen is the appearance of due process with nothing behind it. The McIntoshes won. 2 cities, 2 strikingly similar stories, 2 opposite outcomes. Haddon's emergency was something a jury still had to decide was real. The facts were genuinely in dispute, and a court let that dispute play out. McIntosh's promised touring simply didn't exist. No dispute, no gray area, just a board that was never built. That's the difference between losing a case and winning one. Whether the process you were promised was ever really available to you. And even after cases like these, there still isn't a clear nationwide right to be paid for the structure itself. No federal circuit has ordered the government to compensate a homeowner for a house destroyed this way, a rule the Supreme Court left standing in 2024 in a case where police destroyed a Texas woman's home while capturing an armed fugitive hiding inside, and declined to hear her appeal. 2 justices, Sotomayor and Gorsuch, wrote separately that she'd been left to bear alone the cost of a benefit the whole public received. It didn't change the outcome. The house was still gone, and she was still the one who paid for it. So here's what actually protects you. Keep your address current with the county tax assessor, and don't ignore a demolition or condemnation notice. The appeal window is often the shortest deadline in the entire process, sometimes as little as 5 to 15 days, far shorter than the 30 or 60 days you might get to fix the underlying problem. But the single move that matters most is this. If a hearing is ever promised to you, put the request for it in writing immediately, and keep a copy. That one piece of paper is what turned a demolished mobile home into a due process win in federal court. Because a city can usually survive an argument about whether an emergency was real, but it cannot survive proof that the hearing it promised never existed. Everett Tripodis' lawsuit against Atlanta was still working its way through Fulton County Court as this story was researched, and the investigation into his case pushed the city council to begin reforming its demolition ordinance. Somewhere in that reform process, is a simple, unglamorous fix. Mail the letter to the right street. Next time, the clause buried in most residential leases that lets your landlord walk into your apartment without warning, and why the law usually allows it.
But first, before you close this tab, would you have known to check the address the county has on file for you?